So that would be Larry Hinton and Jason Hinton.
That's correct. I'm here, Your Honor.
All right, good. Good morning.
Good morning.
Morning.
Thank you.
Ms. Hinton, let me get these documents first, and then we'll decide how we're going to proceed. Ms. Hinton has submitted to the court final dissolution documents, which is called findings and conclusions, and then the final divorce order. So first of all, Mr. Hinton, have you had a chance to review those?
Yeah, I got them a couple days ago and I looked over them, and if I can go on and share something else with you, I would appreciate the ability to do so.
Okay, go ahead.
So first of all, I apologize because I feel like I've honestly wasted a lot of time with the court and stuff. I was in an accident, like I said, a motorcycle accident the day after I was served with the papers, and among having a broken hip and ongoing infection with my leg and almost losing my leg, I actually lost a bunch of memory and I wasn't able to function properly. And so unfortunately, I didn't respond accordingly throughout this whole process. And when I finally managed to get it, was able to get the things together and able to respond in time, I feel like I was just a little too late. So I don't know where I go from here. I called the court yesterday. They said I had filed what I needed, but I don't know still if I am or have.
Well, where we're at on that is there was an order of default entered, and then about a month later is when you responded. What typically you would need to do is file a declaration explaining why you didn't respond in time and asking the court to set aside the default.
So I did actually file that paperwork that you're speaking of, the declaration of why that happened. And I think it was a request to reverse the default order or whatever. Yeah. I apologize. It was really quite a lot for me to deal with throughout this whole process, and I apologize again. Yeah, I called the court and they said that I had the declaration filed, and well, she said I had everything I needed filed for this time, but I just don't feel like I do. So
you filed a declaration on December 19th.
So, you know what? Maybe I have it here still. I might not have it might not have got a copy filed for the motion to vacate the default judgment.
So, and I'm sorry to be a little legally technical with you here, but I think this needs to be done in the correct way, and the court has to approach it in the correct way. Because I can't tell you whether, well, I'll tell you what I will do in a moment. I don't know whether I'll set aside the default or not. I need to see a motion. So what you would need to file is something called a motion to set aside the default, and then a declaration. Your declaration on December 19th hits on some of the things, but you need to explain why the accident prevented you from responding in time.
Okay.
All right. And, if you were in the hospital, if you were on medication, if you weren't able to concentrate, those are the kind of facts that the court would need to consider. What I think maybe we need to do,
Your Honor.
Ms. Hinton, I'm going to give you a chance to respond, but I'm going to tell you what my thoughts are at this point. What I'm thinking of doing is putting this over to February 15th, which is in 2 weeks. So Mr. Hinton can file that motion, and on that date, I can make a determination whether I'll set the default aside or not.
Thank you, Your Honor.
And if I set it aside, we'll need to figure out what your objections are to Ms. Hinton's proposed orders. If I don't set it aside, then I'm probably going to sign her orders as she's presented them. I'm not making a decision one way or the other. I just need that brought before the court in the correct manner.
Well, I do appreciate your guidance on this, and thank you very much for.
Let me ask Ms. Hinton if she has a response to that. Go ahead.
Yeah, and his accident, there was no police report. He was going to make a drug delivery and ran into the person in front of him because he was high. I have been told that he walks just fine. He did, I hear, have an infection on his leg, but he has MRSA from his drug use, not from the accident. I was really hoping that you would sign the papers because I want to be done with him out of my life. As you know, we saw you on Monday with his girlfriend, Linda Perez. They continue to stalk me and harass me, and I just want this done and over with. His paperwork that he sent me in it is just stories and lies. And it's difficult for me to take time off of work. As I told you, I'm a mail carrier and people are going to be late today. But if that's what we have to do, then put it off. Then I guess that's what we have to do. But I was just praying that you would just sign the paper. And he took $75,000 worth of tools. He came with more than, or he left with more than what he came with. He came from prison in 2019. We had a very short marriage. He has everything that he needs to live his life. And I just want this signed and done and over with so I can move on as well.
Okay. Understand that. I am going to give Mr. Hinton an opportunity to set aside the default to this. If you have a response that part of what you were just telling me, I invite you to file your own declaration in opposition to that motion, and I'll consider both. Okay. So I think at this point, I need to put this over to the 15th to give everybody a chance to get that paperwork before the court, and then we'll make a decision on that date.
Okay.
Thank you very much, Your Honor.
All right. Thank you. And then Jason Hinton.
Yes, I'm here, Your Honor.
And Laura, I'm here.
Thank you. Let me get to that case here. All right, Mr. Hinton, I think last week or the week before, I indicated you needed to bring a motion to set aside a default, and I haven't seen that filed at this point. Any comment on that?
Yeah, I filed that and everything else because I was under the impression I was supposed to that everything up till now that I was supposed to file, I was supposed to get that in there, and I got in there.
It, sir?
Yes, I did. Yes, Your Honor.
And when did you file it?
I didn't get down there until yesterday. It was the only day I was able to get a ride down there. I got everything done and turned in, and then they turned me away. I had to go and get a couple more things the way they wanted it, and I brought it back down and had it filed. I apologize. I thought that they got the second copy. I brought 2 copies. I mailed Laura's. And
did you provide a copy of all that to Ms. Hinton?
yes, I did, Your Honor. And
I
she
have
may
not received it.
Mr. Hinton, go ahead, finish, and then Ms. Hinton, I'll go to you.
I also submitted the receipt for the mailing it to her in the court files.
Oh, so you mailed it to her yesterday?
No, I mailed hers prior to that, a couple days, I believe. I don't know what the day was. I was able to mail hers. I wasn't able to get yours filed into the court, until yesterday, but I did.
All right. Ms. Hinton, any response?
Yeah, I haven't received anything. And did you get my declaration on why I wish that the default and the dissolution get signed? I turned that in like a week and a half ago.
I did get your declaration. I did read it.
Okay.
Do it.
Yeah, I really would like the default to still be in effect and to have my dissolution signed by you, Your Honor.
Okay, I understand that. It's unfortunate that the documents were filed yesterday, but if they were filed, I think they may make a difference on what my decision is. I think the only thing I can do today is put this over another week so that those can get scanned and get into the court file, and then I'll be able to review them. I am not saying that I'm going to set aside the default at this point, but Mr. Hinton represented that he filed a response yesterday. I'm going to create some time so I can at least review that. So
yeah,
that puts us over to the 22nd at 9 o'clock. And I'll try to take this case early on in the morning so we can make a decision. Okay.
Your Honor, I just wanted to apologize to the court for, I've been having a tough time getting down there, but thank you for setting it over.
Okay. You're welcome for that. And again, I'm not making any promises by doing that. I do want to review your documentation.
All right. Thank you.
Okay. Thank you.
Bye.
All right. Lara Hinton and Jason Hinton.
Yes, Your Honor, I'm here.
and I'm here too.
All right. You're both on the telephone. Thank you for being here. So I did receive the documents from Mr. Hinton asking to set aside the default, the order of default. And I got those actually right after the hearing a week ago. So I'm going to let Mr. Hinton address that motion. Then I'll let Ms. Laura Hinton respond. Mr. Hinton, you'll get to have the last word to whatever Ms. Hinton says, and then I'll make a decision. Okay. So,
all right, thanks.
Go ahead.
I just ask that you just take into consideration everything that was presented to you. I know that I probably went about filing everything and doing it all a little incorrect. It's new to me. And then on top of it, I've been dealing with like I said, the injury from the motorcycle accident. And I just ask that you take that into consideration and give us our chance in court. I honestly don't want and haven't wanted any, ongoing issues and so on and so forth. I've been quiet, haven't, and I've been accused of everything. And so with that said, I just ask that you please consider giving us the chance to have our day in court.
All right. Thank you.
Yeah, thank you.
Ms. Hinton, any response?
Yeah, so I was looking, because I got the paperwork actually that same day as well. And I was looking at one of his exhibits, and it was the one from St. John's Medical Center where he was treated on 10/22. and it says he may return to work on 10/28. He is a general contractor. He is a carpenter. So if he can lift shingles on a roof, and if he can use saws, and the author released him back to go do that, he can turn in paperwork. I mean, that was only 11 days after he was served. And then he goes, and I see the Vancouver clinic, and that's in December. So what happened in the full month of November where he could have responded? He was probably too high. So,
again, I object to that.
Mr. Hinton, you can argue. Go ahead.
Everything is divided out. Okay, thank you, Your Honor. Everything is divided out. He has all of his tools, which were thousands of dollars worth of tools. There is no need to go to court. He lived here for 2 years, and we were married for 5. He had nothing when he came out of prison, and now he has a lot. He has a truck, a trailer, all the tools, the business. He could have kept going if he wasn't using drugs. I got a phone call from the loan company for his big red truck. He had $5,000 to get it out of repo, and now they're looking for it again. So he hasn't made payments, and he is hiding it. They called me asking if I knew where it might be. I don't know where it is. So, I mean, he has money. He's just deciding to spend it on other things. He has a place to live. I just want this over with. I've moved on. There's nothing really that needs to be gone over in court. So that's it.
All right, thank you. Mr. Hinton, any further comment?
Yeah, absolutely. And I've been stopping myself from detailing things and outlining it so far, but I'll go ahead and respond to what she had to say. I don't understand how she gets any information whatsoever, because everything has been wrong so far. We could go into detail as far as, the amount of the truck getting out of repossession and whether or not it is being hidden or not. All of it's incorrect. I don't currently run my business after my accident. Not only did I have major memory loss for a long period of time, and I still don't have all of it back. I'm hooked up to a wound vacuum currently for the wound on my leg that has occurred right after I got out of St. John's, and I have been continually having to take care of it. That's from plastic and debris from the bumper of the car. Everything so far has been wrong. It sounds to me like she does have a lot of stuff to say, and that's fine. I just, again, ask you, I gave you my medical documents and so on, and I have an abundance of more information with that if you would like. I just, I didn't get a fair swing at it. I'm not trying to ask for anything I don't deserve. I got out, worked my butt off, rebuilt the house, did everything, put new appliances, everything, so on and so forth. And as we separated, she damaged the truck severely, $5,000 worth of damage.
All right,
I apologize.
Dealing with those issues now. The issue is simply, should I set aside the order of default?
You're right. I will stop now, and thank you for letting me speak, Your Honor. I just ask that you take the motion into consideration.
All right, thank you. I'm going to get a little bit into the legal weeds here, because if somebody asks for a revision of my decision, I want them to understand. I want the judge to understand my reasoning. So there are 2 defaults. One is an order of default, which has been entered in this case, and the other would be a default judgment, which has not been entered in this case. An order of default, setting that aside, is governed by Civil Rule 55C, which says, for good cause shown, and upon such terms as the court deems just, the court may set aside an entry of default, and if a judgment by default has been entered, may likewise set it aside in accordance with Rule 60B. But we're just dealing with 55C, because what we're dealing with is a entry of an order of default, which the parties may know I was the one that entered that order. According to case law, good cause under 55C requires a showing of excusable neglect and diligence in bringing the motion to set aside the order of default. The kind of the leading case in this area is called Sellers versus Longview Orthopedic Associates. So it arose from our community. And again, for the purposes of whoever may review this, that's at 11 Wash Ave 2nd, 515. In that case, there was an order of default entered, and the court actually found that the attorney acted with inexcusable neglect, but did act with diligence. And so the question was, could you still set aside an order of default if there was inexcusable neglect? And the court said it's still within the discretion of the trial court, and upheld the setting aside of the default in that case. In doing so, the court cited kind of the basic rule, which is courts do not favor default judgments. They want things to go to trial. So the evidence that Mr. Hinton has brought to the court is that he was served on October 17th. The accident occurred on October 18th. He waited 4 days before he went to get treatment. He went to get treatment on October 22nd at St. John. Ms. Hinton is right. That same document shows that he was released to work on October 28th. But it turned out he had a broken hip. And after that, he developed an infection. He got medication for the infection in early December. The court finds that means that it was likely the infection was beginning sometime in November. He then filed, I believe, a response in this case on December 19th, which was after the order of default had been entered. Well, the facts that I just cited, though, I believe constitute excusable neglect for failing to file a response in time. The second question is whether he's acted with diligence, and I'm going to find there was diligence. He's brought this motion prior to any final orders or judgments being entered, and so that would be in the requisite amount of time. If he waited 3, 4, or 5 months from now, we might have a different conclusion. But at this point, I'm going to find both excusable neglect and diligence, which is what is required to establish good cause to set aside the default under Civil Rule 55C. Having done that, I'm going to enter an order setting aside that default. Then the question is, what do we do next? And before this case can go to trial, if it needs to be set for a mandatory settlement conference. And what I'd like to do is put this on the universal trial setting calendar for 1 p.m. on March 8th, which is, I believe, 2 weeks from now, so that a mandatory settlement conference can be scheduled. Will that work for both of you to attend the hearing at that time?
Yes, Your Honor. Excuse me.
Is it a Zoom hearing like this one?
It'll be like this on Zoom, only 1 o'clock
Okay.
on Wednesday. And
Yeah.
okay, if that will work for your schedule, then we will do that with the clerk here. You don't have to file anything. We'll put it on the Universal Trial Setting calendar for March 8th at 1 p.m. And what you'll be asked for is they'll give you some dates for a settlement conference and determine which one works for both of you. And the settlement conference, just so you know, is also on Zoom. Okay.
All right. Thank you, Your Honor, very much.
All right. Thank you. And that's it on that case.